So it gives me enormous pleasure to welcome Tamara, whose second name I've never known how to pronounce correctly. Perišin, Tamara Perišin, to the EUI to give the distinguished lecture at this year's Academy of European Law. I don't know when we first met, but it was many years ago, and certainly long before Tamara commenced her judicial career at the Court of Justice of the European Union, possibly in Florence or possibly in Zagreb. I am not quite sure. But Tamara is a professor in the University of Zagreb in Croatia, where she was the Jean Monnet Chair and director of a center which is called something like the EU Global Relationship and the Rule of Law. She'll tell you exactly what it's called. It's called something like that, according to my illegible notes. So Tamara was already having a highly distinguished career as an academic in Zagreb and had been in that role for some time, having done her doctorate at the University of Zagreb, following a period in Oxford when she was a Chevening Scholar, where she undertook her MJur. And then in 2019, I think it was, Tamara commenced as a judge at the Court of Justice of the European Union, where she has been ever since. And of course, the Croatian government has a good record on gender and the European Court, because we have Advocate General, I don't know how to pronounce her name either, Chapeta, who you all know about because you've been reading her opinion on Western Sahara and the fisheries agreement, among other things, and Tamara Perišin as a judge at the General Court. And we were just talking over lunch, actually, about the gender balance in the Court of Justice as a whole, and noting that there is a significant number of member states who have never had a woman judge or a woman advocate general, which, given that we're in 2024, is something actually that seems quite remarkable. So it's wonderful to have Tamara here with us, and wonderful to have the name of her lecture on the screen, because I actually think that's a bit of my notes that I can't read, and it's Vigilance of Individuals before the Court of Justice of the European Union. And so the floor is yours, and then the lecture will be followed, if you're happy, with a Q&A with our distinguished audience.
Absolutely.
It's a pleasure to have you here.
Thank you. Okay. So I'm really grateful to Professor Scott for the invitation and for the opportunity to be here with all of you. But I have been a great admirer of hers. I have been reading her articles from Croatia. She was always a superstar in my world. So it is a great pleasure to be sitting here on the same table with her. But I know you have had many great speakers, and you have read very interesting materials. So I thought that I would contribute today by discussing something that is my daily work, and this is the activity, the vigilance of individuals before the Court of Justice of the European Union. So this is not something that I have been dealing with as an academic before starting my judicial career, but this is something that I encounter in my daily work now at the court. So the term vigilance of individuals, I've heard it first time as a student of EU law, and this is a term that is often discussed in connection to the Van Handen Laws judgment and to the fact that since Van Handen Laws, individuals can invoke European law before national courts, and then the national judge can set aside national law which is incompatible with EU law and apply directly EU law. So individuals, through their vigilance, through protecting their own rights, are actually protecting the whole EU legal order, and they have actually enabled the court to develop the whole EU legal order. So the EU legal order would never have existed if there were not for all these individuals like Van Handen Laws, Costanel, Defren, and many, many, many others. So I was saying that the vigilance of individuals is typically discussed as this vigilance before a national court of individuals who come to protect their own rights, they have an interest. But in bringing these cases, they've enabled national courts to send preliminary references to the Court of Justice and for the Court of Justice to create the whole EU legal order. But on top of that vigilance of individuals, there is another vigilance of individuals, and that is the vigilance before the Court of Justice itself, so the Court of Justice of the European Union itself. So individuals not coming to national judges, but coming to European judges. And this is what I want to discuss with you today. So in order to introduce the topic, let me first introduce my institution, because I think that the names given to parts of my institution did not do other than cause confusion, because the institution as a whole is called Court of Justice of the European Union, but then it has two jurisdictions. So the General Court would be this pinkish building made of stone. Then the Court of Justice would be the glass building, which you see is a bit higher up. And then the highest are the three towers, which are the headquarters of our interpreters and lawyer linguists. So this is where the services of the court are. So with these two jurisdictions, one can wonder what is the relationship between the two. A simple answer is, but it is possibly an oversimplified answer, is that there is a hierarchical relationship. So the Court of Justice is a higher court to the General Court, because one can appeal decisions of the General Court to the Court of Justice. However, not all cases either get appealed, nor in all cases is an appeal even possible. So a more complex answer is that these are different jurisdictions, because the Court of Justice mostly deals with preliminary references and infringement proceedings against member states, while the General Court is a court that deals with actions against the EU. So the lion's share of cases that come to the Court of Justice of the EU against the EU and that are brought by natural and legal persons, they come to the General Court. So we're, so to say, a citizens' court. I think I've sometimes heard that the Court of Justice is more like a constitutional court, or would like to be a constitutional court, while the General Court is currently something like a supreme administrative court. But now with the new transfer of competences, because we will get the transfer of some of the preliminary references, that it would eventually be developing in a way that it's more like a Supreme Court and a constitutional court kind of relationship. But this remains to be seen. In any case, the General Court is the citizens' court, so it's the one to whom the citizens come. Today I will divide my talk in three parts. First, just as an introduction, I want to briefly remind you of the treaty rules on the standing of individuals and how they have been drafted in a way that reflects the balancing of different interests. Then I want to discuss fields in which individuals appear before the Court of Justice of the EU. And I want to focus on two fields where I think there have been some recent interesting developments. One is rule of law and the other is environment. And then I have some questions for further thought, which can stimulate a discussion, because, you know, judges cannot really come with any conclusions. They can just ask questions. So when can individuals come to the Court of Justice of the EU? The treaty tells us that any natural and legal person may, under certain conditions, institute proceedings against any of the following. And first, the first prong of the test is an act addressed to that person. So if the person is an addressee of the measure, then they can challenge it. An act which is of direct and individual concern to them. Now, this, you know, it is common knowledge for those who have studied EU law that this has been relatively restrictively interpreted by the court since 1960s, the Plowman test. So this is a quite strict rule, which does not allow for huge access to the court. And then the Treaty of Lisbon introduced a change, saying that regulatory acts which are of direct concern to individuals and do not entail entail implementing measures can also be challenged. And there are also some other conditions, so type of act, legal interest, 2-month deadline, and so on. So these rules, they're a reflection of a certain balancing that was done by the treaty makers. So there are arguments in favor of broad standing rules. So it would be great if everyone would have standing. This would be good for stronger protection of individual rights. If each individual could come to the court and challenge any EU act, this would be great for individual rights. This would make decision makers much more accountable. Every act that they make would be subject to judicial review. And it would then mean more judicial review of legality. So there would be a control of all acts. One would check whether it is legal. But in most legal systems, in national legal systems either, you cannot challenge everything that the state does. Typically you cannot challenge legislation, or under very restrictive conditions. So acts of general application can only rarely be challenged even in national legal systems, because too many challenges would make state action difficult. And this is especially true at the EU level, at the supranational level, where decision making is anyhow already super complex. And then another reason that is often mentioned is that this would overburden the courts, because we judges, we already work so hard, and now if there would be many more people coming to the court, this would be impossible to manage. Now, if we look at the fields in which individuals appear as direct litigants before the Court of Justice, we can find easily online. This is the official excerpt from the court's annual report. You see the first column are state aid cases. They're probably put as first because they're seen as very important. I don't know what other reason could it be, because they're not the most numerous. But traditionally, these state aid and competition cases are seen as the core of our workload. These are very important cases in terms of their value. So we have had these huge cases, billions of euro worth, on Apple concerning whether certain tax regimes constituted state aids. So Apple, Amazon, Fiat, Starbucks, so on. Now we have had a great number of cases that arose from the COVID pandemic. So most of the cases are called Ryanair, because Ryanair challenged state aids that were given by most member states to their national airlines. So to Air France, to Delta, to the Portuguese TAP, to Scandinavia, to Croatia Airlines, and so on. But Ryanair didn't get state aid, so they challenged it. So these are really, the value of these cases is really high, the monetary value. Then competition cases, these would also typically have a high amount of money involved. Maybe our biggest would be these Google cases that concerned the European Commission's fine to Google for breaching competition law, which goes around 4 billion euro. Then the two very big groups where we have a lot of cases are staff cases and intellectual property cases. Those are the only cases where we can specialize. All the other cases we are evenly attributed to judges, but you can opt either to do staff or to do trademark. So nobody does both. So I was firstly doing trademark and then staff. But all the other cases, state aid, competition, environment, banking, they're just equally attributed to all judges. Now, what is, I think, most interesting are not these four, but these other direct actions. And these other direct actions are banking, let's say the withdrawal of banking permissions, of banking authorizations by the European Central Bank, public procurement, access to documents, international trade, restrictive measures. But there are also some, within that, there are some that are not visible in the classification because, let's say, rule of law, if you look at the court's report, it does not appear as as a category, because rule of law cases one appears as a restrictive measure case, another appears as an access to documents case, and so on. So I find finding fields which are not administratively categorized as fields, I find this most interesting. So I chose the topic of the rule of law because I think nobody really knows that the General Court does anything in this field. So the rule of law, as you know, until 6 years ago, it was not even a real legal topic. I would get invited maybe 10 years ago, 20 years ago. I got often invited to talk about the accession negotiations because I was on the Croatian government's accession negotiation team. I was on the team that was dealing with free movement of goods. But I would honestly tell them that we did not negotiate that much in the field of free movement of goods. All the core areas, like the internal market, were not really negotiated. These areas, the chapters were opened quickly and closed quickly. The area that was negotiated the longest, the chapter was closed the last, was the rule of law chapter. And back in the day, the conventional wisdom behind it was that rule of law is the field where after accession there was nothing that the Commission could do about it. So unlike free movement of goods, if a member state was later in violation of free movement of goods rules, the Commission could bring infringement proceedings, an individual could invoke free movement of goods before the national court. So there were remedies for any possible breach. If anything went wrong during the negotiations, no problem to solve it afterwards. But for the rule of law and the well-functioning judiciary, the common wisdom was that states must be forced in the pre-accession period to establish well-functioning courts, because after a country exceeds and becomes a member state, that there was nothing that could later be done. So that was really the last chapter that Croatia closed. But since 2018, we know that the rule of law has become a topic in EU law ever since this crown jewel case of Portuguese judges, where the court found that it is able to control rule of law compliance in different member states on the basis of 3 provisions, looked at them cumulatively. So this Article 19 of the TEU on effective legal protection, on the basis of this that rule of law is one of the fundamental values of the EU legal order, and that there is the Charter and the right to an effective remedy and to a fair trial. So that all this gives possibility for judicial control. And then, since then, there has been so many cases and so many academics writing about it and blog posts. So this has really, there was a period when this was like the topic in EU law. If we look at the type of cases that these were most often preliminary references, sometimes coming from a member state concerned. There were many preliminary references from Poland, where Polish national judges were seeking interpretation or a decision on the validity of a piece of national legislation. Sometimes these were preliminary references from another member state, not from the one concerned. Let's say preliminary references from Ireland asking how to interpret rules concerning the European arrest warrant and whether the distrust in the Polish courts should make the Irish judge refuse transferring a person to Poland. Then there were many famous infringement proceedings, either brought by the Commission, so typically against Poland and Hungary, but there were also infringement proceedings of one member state against another. Here in Croatia, a very well-known case is Slovenia versus Croatia, where Slovenia sued Croatia, arguing that Croatia is violating EU law by not implementing the decision of an arbitration tribunal. And then there were many actions for annulment, but only those submitted by privileged applicants, like Hungary against the parliament, they attracted a lot of attention. But what I saw, this is what I saw as an academic, and there were conferences, and I had a Jean Monnet Center of Excellence, and on the rule of law, and use global leadership in the rule of law. But then as a judge, I saw many ordinary people making rule of law arguments in front of our court. And I got interested in that, and I wanted to see what role could individuals play in bringing rule of law cases which would otherwise escape judicial review. To you today, I want to present just this part on privileged applicants. So I will discuss briefly 3 cases, but this is just to give you some illustration of what kind of cases we had. So we have had cases where the General Court was asked to take account of rule of law violations happening either in a member state, so here the example is Homoki versus Commission that concerned Hungary, or in a third country, Ben Ali from Tunisia, or at the EU level, so this is, for example, Mendes de Almeida or Ferrell's cases. So Homoki. So Homoki is a case coming from Hungary that concerned the putting of public lights in Hungary. So in Hungarian newspapers, there were a lot of articles that there has been some corruption in this field, that the lamp posts were not put at a distance that they were supposed to be put, but at a bigger distance, and that the lights were not of adequate strength, so that there was some sort of corruption and in the placing of public lights. And Olaf, the European body in charge of investigation of corruption and fraud, conducted an investigation and sent a report to Hungary. And now the applicant, Mrs. Homoki, she is a representative of the civil society, and she asked Olaf to give her this report. So she wants to read what it is. There was a lot of discussion in this in the Hungarian newspapers, but no one actually knows what happened, but it will be in the Olaf's report. So she wants to know. Olaf decides not to give her the report, and they say that that they cannot give it to her in order to protect the investigation and to protect the identity of the informers and investigators, to protect personal data, and to protect commercial data. And she says, but I don't need those data. Can you cut out this data and just give me the rest of the report? And they don't give it to her. So she comes to our court and she challenges Olaf's decision not to give her the report. So this comes to our court as an access to documents case. And she's invoking, there is a fundamental right in the Charter of access to documents. There is a fundamental right of freedom of expression, which contains the freedom to receive information. And then she's also invoking an overriding public interest, and she says that the overriding public interest stems from the fact that the Hungarian authorities cannot be expected to carry out a substantive examination of the abuses carried out by Olaf, and that only publicity in Hungary is an effective means of control. So she's saying the public authorities in Hungary, because of the rule of law situation, cannot control this adequately, so the prosecutors, the courts. She's invoking a rule of law argument and saying there is an overriding public interest that you give me access to this report, I will publish it, and that is the only way to conduct control. So the General Court is asked to check whether Olaf checked whether in Hungary there were indeed such rule of law breaches that the Hungarian prosecutors and courts could not be expected to do anything about with this Olaf report. So we are checking whether another institution checked the rule of law compliance in a member state. And in this case, we annulled Olaf's decision not to give her access because we found that there was no investigation taking place in Hungary, that there was no follow-up of this Olaf report, so that the protection of the investigation could not be invoked for refusing access to the document. Of course, the personal data of informers and investigators was supposed to be erased. Then Ben Ali case, and I have many Ben Ali cases because Ben Ali is a well-known family in Tunisia. Ben Ali was a former head of state in Tunisia. So in the aftermath of the Tunisian revolution, the new government in Tunisia opened many investigations and criminal procedures against members of the Ben Ali family and other people connected to the old regime who were suspected of misusing public funds. And the EU, which sided with the new regime, then froze within the EU the assets of all those people against whom Tunisia opened investigations. So one of the people was a Ben Ali who was a relative of the former head of state Ben Ali. But in our case, this Mr. Ben Ali is arguing, my assets have been frozen for more than a decade. Tunisia just opened investigations and is not doing anything about it. I'm a victim of a political persecution in Tunisia. It is not that I have misused public funds. So the General Court is asked to check whether the Council checked the state of the rule of law in Tunisia and whether in Tunisia this person is indeed getting a free trial, a fair trial, and whether indeed the investigation is progressing or not. So in this case, again, we annulled the freezing of assets because we found that the Council did not do sufficient verifications of the state of investigation in Tunisia, since that has been open for more than a decade, but with no progress. And then in Mendes de Almeida and Verhelst, these are interesting cases because they concern the rule of law protection at the EU level. They concern the appointment of European prosecutors. So in the process of appointing European prosecutors, there is a committee that ranks national candidates, and then the Council looks at 3 candidates that were top ranked, and the Council selects prosecutors from each member state that is participating in this European Prosecutor's Office. So for all, except for 3 member states, the Council chose the person that was ranked number 1 on this ranking of this independent committee. But for 3 member states, the Council did not choose the first person, but someone else. And Mendes de Almeida and Verhelst are people who were ranked first, but did not get the job, and then they challenge it. So in Mendes de Almeida, the General Court found that the application was submitted after the 2-month deadline, so it did not go into the merits. In Verhelst, it found that the action was unfounded because actually, according to the General Court, the Council was not bound to take the first person, but just to take one of the 3 on the list, and that there was no special duty of this statement of reasons. But the fact that the court found that there was no violation does not mean that these cases are irrelevant. They still show that there is judicial control over the rule of law standards that the EU itself must uphold. So what we're doing in these rule of law cases, and these are just some, there are many more, is either indirect control over rule of law compliance in a member state, in a third country, or in the EU itself. And these are cases that would otherwise escape judicial review. Now, the other field that I would briefly present is environment, which then overlaps with climate change, health, and animal welfare, depending on the case. And I find it very interesting that in the last 5 years, if we look at the case law, but then Professor Scott is a much bigger expert in environment than me, but I have had the impression that the biggest cases actually came from the member states, and these climate change cases are member state cases. For example, in the Netherlands and in France, there were these cases where individuals were challenging the lack of action of their national governments in the field of climate change. And they were invoking Article 2 of the European Convention of Human Rights, the right to life, Article 8, the right to private and family life, and seeking damages. And in these member states, the national courts actually found that states were obliged to act. But have there been any EU cases of the sort? Or is it just in member states? Because climate change is also not a problem that one member state could solve. Even the EU as a whole could not solve it, but it has better odds in doing something than if just member states do it on their own. So just to remind you of these of the three-pronged test, because I will now discuss the cases on the basis of the three-pronged test. So an individual can come to the court if an act is addressed to that person, if he or she is directly and individually concerned, or if there is a regulatory act which is of direct concern to that individual and that does not entail implementing measures. So these are prong 1, 2, and 3 of the test. So if we look at the case concerning the first prong, I will use as an example the case Client Earth, which concerned, there are again many cases called Client Earth because Client Earth is a big NGO in the field of the environment, but there is a reference with a number. So this case concerned construction of a biomass power generation plant in Spain. And the European Investment Bank, the EIB, approved financing of the project with up to 60 million euro. Now, Client Earth, an NGO, had doubts about the sustainability of that project and about compliance with EU's environmental objectives. And on the basis of the Aarhus Convention, it asked the EIB to conduct an internal review of that decision. Because under the Aarhus Convention, NGOs had the right to ask for an internal review of certain acts, administrative acts in the field of environmental law. It used to be just administrative acts of individual application, now it's also of general application. But the EIB said, no, we're not obliged to do an internal review here. You are an NGO which would be entitled to ask it, but they rejected it, saying that this was not a type of administrative act for which the Aarhus Convention would be applicable. And now Client Earth comes to the General Court asking us to review the EIB's decision not to review the act. So the first barrier that they have to overcome is whether they have standing before the General Court. And here, the Aarhus Convention enabled them really that there is no problem there because they are the direct addressee of the decision, of the EIB's decision not to review the act. So they overcome this hurdle and they do have standing before the General Court. And then the second hurdle is whether the General Court would consider that this is a type of act that would be subject to the internal review under the Aarhus Convention. And here the General Court found yes, the EIB was supposed to conduct an internal review. The concept of environmental law must be interpreted broadly, and then the type of acts which should be reviewed should be interpreted broadly. So here the applicants get standing and they get the outcome which they wanted also. Then another example is with the second prong, so an act which is of direct and individual concern. This is a case Carvalho, and the case concerned the EU climate change legislative package of 2019. So this is a number of directives, regulations, so of legislative acts of the EU that were challenged. And who challenged it? So it was challenged by families from member states, Germany, France, Italy, and so on, from third countries like Kenya and Fiji, who were active in the tourism and agricultural sectors, and also by the Swedish association representing the young indigenous Samis. And they were seeking stricter rules on greenhouse emissions. So do they have standing? No, under EU law, they didn't have standing. Why? Because they didn't have individual concern. Because this is very standard EU case law since 1960s. Individual concern means that you must be affected by an act individually, as if the act was addressed to you personally. And the bigger the problem is, like climate change, the less number of people, the lesser are the chances that someone will be concerned individually. So the bigger the problem, the less chances of individual concern. So this is very standard EU case law. The court did not do anything out of the ordinary here. So the families that brought the challenge and their lawyers must have advised them to bring this case either to bring visibility to the problem or because they thought that the court could perhaps make some breakthrough from the old case law like it happened in the Netherlands or in France. But the court considered itself constrained by the treaty rules and probably assumed that that kind of a change would require a treaty amendment, so it just repeated the standard case law that just the test is not met. The criteria established by the test are not met, and it is a problem, but it is for someone else to deal with the problem, not for the court. And then now with the third prong test, I want to contrast two cases, because the first prong, you get standing. Second prong, you almost never get standing. Third prong is actually the most interesting because it's also the newest one. It was only added with the Treaty of Lisbon. That is, of course, 15 years old, but it takes you a decade to see what a treaty amendment does. So this third prong says that for a regulatory act, so this is not legislation, but a regulatory act like implementing regulation, if it's a direct concern and does not entail implementing measure, then an applicant has standing. I will contrast two cases. The first case is this Ville de Paris. It concerned 3 cities, Paris, Brussels, and Madrid, that challenged EU rules on emissions. Precisely, they challenged the Commission regulation regarding emissions from light passenger and commercial vehicles, Euro 6. So these are some car emission standards. And each city brought an action for annulment before the General Court because they wanted higher standards, they wanted stricter standards, and they thought that the existing standard, that the standards that the Commission adopted were contrary to higher EU law. And the General Court found that the cities did have standing because this was a regulatory act which did not require implementing measures, and that they were of direct concern because these cities had the powers to regulate circulation of vehicles in their own cities to protect air quality, and that when the EU adopted this, when the Commission adopted this regulation, that this affected their powers, so that they were directly concerned. So the General Court says, you have standing. But the court thought that the General Court made an error, and the court, on appeal, annulled the General Court's decision and said that the cities were not directly concerned. You know, I can never comment on judgments, so let me just contrast this with another case. So Troy Chemicals case, and there are many like Troy Chemicals, so this is just an example from many. So this case concerned a chemical called carbendazine. This is a substance that protects paints and plaster from fungi. It is typically used, it used to be used outdoors in paint, but the problem is when there is rainfall, and then this chemical goes into the water and it can cause pollution. It can impact the life of different species, both in the soil, if I remember correctly, and in the water. I don't remember precisely what it does, but it certainly was not in accordance with the EU's environmental and animal welfare standards. So the Commission adopted an implementing regulation where this carbendazime was approved in film and construction material preservatives, but not for outdoor use. And producers were very upset by this because outdoor use was very common use of that product. So they challenged this, wanting outdoor use of carbendazime. And it is interesting because before the General Court, producers always have standing. They're always directly concerned because whenever it's an implementing act, a regulatory act with no implementing measures, it affects certain producers, it affects their legal situation, what they can place on the market, what they cannot. So they did have standing. So, but in this case, the General Court found that they had standing, but it rejected their application. But there are many others where the General Court first finds that a producer has standing, and then it accepts their application. We have had a case which is now an appeal on titanium dioxide. There are many titanium dioxide cases, but this one concerned titanium dioxide in cosmetics, which the Commission wanted to label it as potentially carcinogenic. The producers did not want this to be either labeled as potentially carcinogenic or for that kind of information to appear on the packaging. And the producers, the General Court found in that case that that producers had standing, and also they annulled this implementing regulation. So currently, I think titanium dioxide is not listed as potentially carcinogenic, and this does not appear on cosmetic products. So there are many cases where producers get standing, and sometimes successfully, sometimes not, and they challenge this. Now, this I find very interesting. Maybe now the letters here are a bit small, but the regulator, when they're adopting a piece of legislation, they do a balancing between different interests. And there is a lot of lobbying, I would presume, from all sides to put whether a certain chemical is allowed or not. I would assume, I've never participated in the legislative process, but that you need to take into account the interests of producers, the interests of the functioning of the internal market, the interests of the consumers, health interests, that there is lobbying and pulling in each direction, and then whatever is a result of a certain political compromise that was finally reached. And then this compromise, this balancing that was done, affects how businesses will function, how individuals, what kind of rights they will have. It affects the society. But then, once this gets challenged, we wonder whether the same balancing is adequately done before the courts, and whether even all individuals could come to the court if they wanted to. So the questions for further thought, and this question maybe relates more to the rule of law issue, is given the importance of the vigilance of individuals, should the rules on standing of individual applicants be broader, or maybe not? How could they be made broader? Is this through a treaty amendment, or is there room in the interpretation? What would you like to challenge? And also, connected to the environment, do the standing rules assure equal access to EU courts? How do they affect the lowering and increasing of standards? So I showed you an example of cases where producers typically would want, let's say, lower environmental healthcare standards, consumer protection standards, but they typically, under the third prong, they get access to the court. They are directly concerned. But those who would want higher standards, let's say consumer associations, cities, and so on, They're not directly concerned. So there was a balancing that was done by the legislator or in adopting a regulatory act, which was done in the decision-making process of the regulator. But then the standing rules maybe tilt the balance between these interests in giving greater access to the courts to those who would want the lowering of a standard. And is any possible imbalance compensated by other rights, such as access to documents, which then allows for public scrutiny of a certain issue, that the public gets to know that, let's say, something is potentially carcinogenic, or by rights like in the Aarhus Convention that then enable an NGO to ask for an internal review, and then they become somehow, then they get standing under the first prong test. And should standing rules maybe differ on the basis of the field of law and the importance of the legal issue? Should the rules on standing really be equally applicable in all areas? I remember many, many years ago, there were, I think this was Advocate General Jacobs who wrote about giving greater standing in the environmental field. And maybe should the Court of Justice have some discretion in deciding which cases to take on? This I know now sounds very controversial, but for example, in the US, the Supreme Court picks its own cases. They don't take on all the cases which are submitted to them. They decide which case they want to take. So this was just a small overview of what I've been doing and what I found interesting. And you see that many things I cannot discuss, but I gladly answer questions to the extent that I can. So yes, thank you.
So thank you so much, Tamara, for that fascinating lecture. And there are many privileges to being a judge, but freedom of expression is unfortunately not one of them. So we will ask questions and we will receive some answers, but I am certain that we will also receive some pushback when it's not possible because of Tamara's role to answer us expressly. So who wants to kick off with questions or comments? Go ahead.
Yeah, thank you for the distinguished lecture indeed. Concerning one of your questions that you asked on your last slide, should we differ concerning to the fields that we look on? I think that is exactly what the ECHR did, the European Court of Human Rights did, in his judgment on the Klimaseniorinnen, the climate grannies, aînées pour la climat, because that's where he said he needed a differentiated approach, right? And he diverted a little bit maybe from the text of the document itself. But in my personal opinion, I think it's a smart move to like pick out this very specific field and try to not have everybody come to the court and try to get something out of it, but to professionalize it a little bit, because he differentiated between the associations on one hand and individuals on the other hand. And just, I mean, I cannot ask you if you think that is a possible path for the European Court of Justice as well, but from a professional perspective, how do you view that decision? Do you find that groundbreaking? Were you surprised? Would you say, looking at the decisions so far, one could have seen that coming because that was the direction the courts are going? Just kind of an opinion from you in that direction would be interesting, I think. Thank you.
Yes, thank you. No, I cannot comment on other decisions, even from other jurisdictions. I can just tell you they're very interesting. But I think that our court, we might get surprised with the judgment, but typically to make a big change, they would want some sort of a possibility if the treaty amendment would change a bit, and then maybe this could be interpreted more broadly. in my view, maybe this treaty amendment has already happened. So it has happened with the Treaty of Lisbon. So this did give a chance to change, but really the repercussions of the Treaty of Lisbon are only becoming clear now that this maybe unbalance is happening. But the court is reluctant then to say, oh, we've seen in practice that this is really leading to certain results, so let us now change the jurisprudence. The court is really not inclined to be making any big changes unless it gets a clear instruction to do so. So I think that maybe as there is more and more law, that the changes that the court is making are smaller in a way, right? I think that maybe the period of Van Hand and Costa and AEL is not at this moment alive. Maybe it's due to the political situation, to various crises that the European Union has been confronted. Maybe also now there will not be a big change because we're currently doing a reform of the judicial structure of the court. So the General Court got a double number of judges several years ago. So I came in the enlargement of the General Court in 2019 because we had a huge backlog of cases, and then the General Court doubled the number of its judges. Now we dealt with the backlog, and now the consequence of needing to use our resources is, and the court having too many cases, is that we will get a part of their cases. So I think that until we see how that is playing out and how the General Court is now also dealing with the preliminary references, because now 2 chambers, we have 10 chambers, 2 chambers will be, as of September, will just be dealing with preliminary references. I don't think that for now big changes in the standing rules are possible unless the treaty makers change something. But the court has annual meetings with the judges in Strasbourg. It also has annual meetings with judges of the Supreme Court of the US, or maybe it is every 2 years, I forget. We have meetings with highest court judges of member states. And then, of course, they asked, so how did you do it? How did you manage? How did you? So who knows, maybe through these dialogues some sort of change in the paradigm happens, but I don't know. This didn't answer your question, but as I said, I cannot.
I'm going to collect a few questions, and I'm going to be very cheeky and put myself in the queue, which I don't normally do, but the one category that you missed out of your list, which I think would come under the heading individual concern, maybe as a subcategory, is the category of persons who have a right to participate in the process leading to the adoption of a decision. And one of the things we've looked at a lot in the course over the last few days has been the increasing importance of consulting named stakeholders in decision-making processes. So that seems to me to be one way of enlarging the standing possibilities without allowing access to everybody to the court. And I just wonder, you didn't mention that category, and the court has taken a very narrow interpretation of that category recently, and I can't ask you to comment or to evaluate that narrow interpretation, but just to comment on how important you see that particular category of standing potential as being. I'm trying to find a way of formulating the question that doesn't require an opinion, but not doing very well. And I'm going to take two more questions, and then we'll pass back to you.
Thank you very much. I just wanted to go further on this, on the reform of the procedures, and also picking up on different things that you said. The reason why standing is limited is because the workload would otherwise be too heavy. And we also know that the court always says that the reason why standing is relatively limited is because we have a complete system of remedies in the EU, and the preliminary reference procedure is a full part of that, and citizens should in the first place address their national judges. And this is, there's no yes/no answer, and then also there's a whole treaty question, of course. But do you think that if we would open up the category of standing, and if we would relax the rules on standing, maybe citizens would be, maybe the workload on preliminary references would be a bit lower, because that's in the end the reason why the General Court has taken on this load of the courts. And so maybe it's communicating phases as well. So yeah, that was the question.
Thank you very much for the lecture. This is a perfect question to follow. I'm going to preface this just by saying, I know you're a judge with a lot of academic experience, so I'm going to just ask this to you as an academic with a lot of judicial experience, and hopefully that way I can circumvent what you can and cannot say. But this question is specifically, a lot of you lawyers are sort of allergic to this notion, but I feel like, okay, we can't widen direct and individual concern, because then you would have, the floodgates would open. But why don't we have on the EU level some kind of actio popularis variant? Because I don't think the NGO route is enough. So would you think that maybe introducing some kind of actio popularis, where people with certain thresholds, certain specific requirements, which would give individuals a route, direct route to address constitutional deficiencies, could that potentially improve standing, effective judicial protection, complete system of remedies without opening the floodgates? Thank you.
Tamara, I'll pass back to you while I then gather some more questions for the next round.
Okay, thank you. Thank you to Professor Scott for mentioning this category of persons, of individuals who have participated in the decision-making process, who were consulted.
From microphones that don't work well to furniture being destroyed, we offer you.
What next? You won't make it to the next meeting.
So we have this issue of people participating arising in various fields. I have dealt with a public procurement case where a producer of drones, Frontex was buying drones that are used for the surveillance of the Mediterranean, and it conducted several rounds of certain testing, and the company participated in several of the rounds, but then Frontex, when it opened this call, how is it called, the bid? No, my French.
Tender.
The tenders, I'm sorry, yes, because I think in French now about this. When they published the tender, they only asked for a different type of drones. I don't remember now precisely, but some could cover one distance, the other could cover another distance, and there was this issue. Then we had this issue with international trade agreements with companies that were consulted, where the new trade agreement with Brazil was being negotiated. We had this in anti-dumping, so in many, many fields. And I noticed that in many, many fields, the applicants think that this should give them some rights, because they have invested a lot of effort, time, money, to participate in this, and then in the end they're not satisfied with whichever area they want to challenge, and they think that the participation gives them a special right, and it could be, but the court, it would not be, the treaty text itself would not prevent an interpretation under which they could have standing. But just the standard jurisprudence that dates, that is more than 50 years old, took a very narrow view, and it is very difficult then to break out of the existing jurisprudence. But the treaty text, is very vague. So the words individual and direct concern, if you would ask, a lawyer who has not studied EU law what it meant, they could come up with 100 possible understandings of this without going too far from the text itself. But so the jurisprudence is really hard, and now maybe even with the court with so many member states and so many different chambers, it is a bit maybe even more difficult than before when the court was relatively small, let's say with 6 member states and then just 6 judges. It is a bit difficult to depart from existing jurisprudence, but there is nothing certainly in the treaty text that would prevent it. But we've had many cases in many fields, and the interpretation remains quite narrow.
I mean, so I had a wonderful student who defended his thesis here a couple of years ago called Mario Pagano, who wrote on standing mobilization by environmental groups. And Mario's argument in his thesis, building on the very early work of Trevor Hartley, was that there is a category of individuals who does get standing through this rationale that they've been involved in the decision-making process, and they are economic actors in anti-dumping proceedings, in competition law cases, and in state aid cases. And so he argued, I think very convincingly, building on Trevor Hartley's concept of a quasi-judicial decision, that it's not that the court's jurisprudence is exclusionary entirely, it's that it's sometimes quite open, and actually it's sometimes exclusionary. So there is a real inconsistency which privileges economic actors as compared to, for example, environmental actors. That was his argument, at least.
Yes, I've seen many similar arguments in other places. So in, let's say, in state aid cases, the formula of how you get invited, how you get standing is that you must argue the violation of your procedural rights. So this is how you get standing. And then there were cases where the standing was a bit more broadly interpreted, like Montessori case. In Montessori, so it was not only the aid beneficiary of state aid who was considered entitled to challenge something, but the competitor of the aid beneficiary. And then I've heard the argument that the court is willing to extend standing rules where it serves the interests of the internal market, but not so much in other fields. Why this is so, I'm not certain.
At liberty to say.
I honestly don't know.
So we had also questions, Anthony.
Yes, so I found this question very, very interesting about whether there are so many preliminary references because the standing rules are really too strict, and if we would broaden the standing rules, then we would get less preliminary references because they just go to the national court in order to, and sometimes even artificially construct a case and to come to the Court of Justice. But really, in many cases of standing, of vigilance of individuals before the Court of Justice of the EU, the problem is that the individuals cannot come to a national court. So in the Homoki kind of case, where the applicant is really concerned about the problems with national courts, she cannot construct a preliminary reference from a member state. It's really the Court of Justice that she needs to go to. In Ben Ali cases, he cannot get a preliminary reference from Tunisia. He must get access. And so it is not always possible to construct a preliminary reference. There are books now that have been written about this, how to create a preliminary reference, these ghostwriters and so on. But it is not always possible. So this is why the two work in parallel. And indeed, I'm certain that it is true that if the standing rules would be broader, that there would be less preliminary references. And then with Actio Popularis, yes, why wouldn't there be an Actio Popularis? But who should introduce the Actio Popularis? Should the treaty maker allow for the Actio Popularis, or should the court just one day wake up and say, today we have decided that in environmental law, you can all come to us if you have a concern. This probably, would cause the court a lot of legitimacy. So it's probably for the treaty makers to make such steps. And whether the court could still do more within just by interpreting the written rules, maybe, but it is really for the academics to give ideas on what to do and how to do it, and in which fields something could be done wrong. And then it's great to invite judges to tell them this, but not just me, or for academics to come to Luxembourg and to give a talk about this to judges. That is actually, that will be very good.
So Mario Pagano has recently started to work in the commission in DG Environment, so he would be an excellent person to invite to the court to talk about this issue also.
Also Professor Scott would be in.
When Professor Scott has fewer than 16 PhD students, she promises to come. I must say, the General Court has been very courageous in this area. I mean, some of the early cases, like the UPA case, where the General Court did step outside the boundaries of the Court of Justice's case law, I thought was very impressive. But the General Court got slapped down rather firmly by the
This is what I get asked about. So why doesn't the General Court do more? And you would expect that anyway, a lower court can be more courageous, more cheeky, try out new things, and then if it went completely off, then this would get struck down by the big court, and the big court would correct any damage done. But my impression is that judges don't like being slapped down. They care what the big court thinks, and if in a certain field the big court has shown that is not willing to extend the standing criteria, for example, then the General Court is in a way hesitant to propose a new change. It just repeats this is standard case law. It has already been struck down. The fact that something has been struck down 5 years ago does not mean that it will be struck down today. But I assume that there is still a tendency to stick to what has already been previously established, to stick to the existing case law and not to reinvent the wheel. And why, I don't know.
So we're going to take don't have my mic on. Marina, I haven't got my glasses on, so I can't see your name. I'm sorry. Which is
Helena Jeromi.
Thank you. I should wear my glasses, and then Claire.
Thank you very much for the lecture. I wonder if I could ask about another potential rule of law gap in Article 263 that has to do with the nature of the act being challenged has to be an act of an EU institution, agency, or body. And in particular, I'm thinking of there have been a number of recent judgments or cases where individuals who otherwise satisfy the strict standing criteria that we just discussed, who are affected by the common accord decisions of the member states. So that is acts taken by all of the member states collectively in their sovereign capacities instead of as a configuration of council or as the European Council. And the individuals that are affected by those decisions appear before EU courts, and the response from the courts has been there's no jurisdiction over the acts of the member states. And what isn't considered in the assessment are the links to and the involvement of the EU institutions, the embeddedness in EU procedures, and also whether or not there are alternate channels of review. So whether there's a national act that can be challenged or whether it's possible to construct a preliminary reference. And so I guess I'm just wondering if you can share any of your thoughts on that type of rule of law gap and whether or not the absence of a judicial remedy sort of in the system of EU and national judicial cooperation, whether or not that gap is something that can be filled at the EU level.
A couple more.
What was the second part of the question?
Essentially, just whether or not the court can check if there's no alternate channel of review, so whether that be at the national level or sort of an ability for it to come to the court via preliminary reference, whether or not that's something that could be a basis for asserting EU jurisdiction over that act. Thank you.
Marina. Helen.
My question leaves a little bit the topic of your talk, but it was spurred by some parts of the answers you gave now. You were referring to the court's legitimacy, and I was thinking throughout your presentation that every case that comes to the court and where the court is bound to decide gives the court also political power in a way, because every time the court has the chance to say something new, then it's also like a political power that we cannot underestimate. And sometimes I think the court interprets a provision in a way that is novel and that no one hasn't heard of before, or that even almost amends the act, and sometimes it does not. And I'm interested in, and I don't know whether you are able to answer this, but I was wondering whether these thoughts are the criterion of the legitimacy of the power that the court has does play a role in the evaluation, in how far something can be interpreted or in how far something can be novel. Thank you.
Thank you so much, Helen. And Claire?
So thanks so much for this lecture. It was just incredibly masterclass in how to give a really interesting public lecture. So I just want to go back to the Carvalho case, because, you know, we did a little course, Joanne and I, with another colleague on legal mobilization. We put this Carvalho case on, and everyone was saying, but what was the point? You know, what was the point going to the court, going to the Court of Justice with this case when it was absolutely obvious that they were never going to have standing? And we had some of the people who were involved in the case discussing why they had taken this case, even though they knew they were going to lose. So I thought that was kind of interesting. So they said, you know, our strategy, and this is something that Mario Pagano, who's Joanne supervised, but I examined, so I also got to read the thesis. So he says, you know, you've got to think about environmental actors, climate change activists, building up a pattern. So they go to the important national courts that you mentioned in your case, that never heard before, Swiss grannies. I've heard it called other things, but not, you know, you get the Swiss grannies case, you get these important national court cases, and then going to the Court of Justice, knowing it's going to be a no, but with people from Kenya, people from Fiji, that is part of the strategy, even though they know the court will say no. So what is it strategically for? So first, it's to make visible, also in the media, that EU law, and in particular EU judicial protection, is out of step. You know, and the more other cases you have, the more the Court of Justice looks out of step. So that's one part of it. The other part, which is a more positive kind of, is to give courts what he calls in his thesis, judicial comfort. So the idea being, courts look at each other and they read each other and they meet each other, and they might think, oh my goodness, this is too bold. But then, oh look, in Strasbourg they're doing it, in the Netherlands they're doing it, in France they're doing it. Maybe we can feel it's not such a big step for us to take after all, when we see all of them doing it. So one audience is to give what he calls judicial comfort to the court. So a bit, I wonder, is this really going to work? But the other would be to say to the treaty makers as well, because they are also an audience for this strategy. Don't you see how out of line EU law is? You're supposed to be a leader on climate. You should do something.
Obsolete, he called you. Obsolete. It makes the European Court of Justice look obsolete. It was a rather strong term.
So I guess I wonder, so he's thinking this strategy can either be addressed to the Court of Justice judicial comfort, or it can be addressed to the treaty makers. So insofar as one can, I mean, I guess my instinct is it's going to be a more powerful, it's more likely to be effective addressed to the treaty makers, given how long-standing this jurisprudence is. But if you had any thoughts on that. And then one other micro question, because we've got a great opportunity to have you here. So one thing that's clear from your talk, but that we're all sort of grappling with when we think about the Court of Justice of the European Union, you know, that your slide picture showed beautifully, is how big it's getting. You know, we've gone from like a few blokes sitting around a very small table to, you know, this very large organization. So that presents a challenge, of course, for a court that gets much, much bigger. So I just wondered if you could tell us anything about the sort of routines and mechanisms that you have created or reinforced to make you a unified general court and a unified Court of Justice of the European Union with your colleagues in the European Court of Justice. Have there been innovations? Or anyway, whatever you could share with us about that would be just wonderful. Thank you.
So the first question was about this rule of law gap. You called it that way, that arises from the fact that not everything is subject to judicial review. I have to say I have never heard I have never heard the term rule of law gap for that, but you might be right that it is a rule of law gap, but somehow there are also in member states, there are many acts which just totally escape judicial review, especially some high-level types of decision-making often escape judicial review. And you have rightly pointed out to the fact that some acts just per se are not challengeable, and that the court maybe had other options of how to interpret the challengeable act differently. But there are also many other examples of this. We have had cases, for example, it is KSKD concerning EU's missions in Kosovo, which is now on appeal. But the General Court considered that this falls under the common foreign and security policy, and that this is why the judicial review is not possible. So the treaty itself provides for areas where the court does not have competence. Sometimes the court has interpreted broadly certain provisions. So in the KSKD case, there was, for example, an argument that this also concerns the application of the Charter, and that the Charter, that the court always has jurisdiction to look into the violations of the Charter, even when the EU is acting extraterritorially or even in the, let's say, common foreign and security policy, and so on. So there are probably possibilities of how to interpret something differently, but just already what you call the rule of law gaps, they're already provided for in the treaty. So the treaty tells us you, the court, should not be reviewing certain fields. Now, whether there is other type of judicial review of those acts, that I don't know, but it is possible that there is not. This would probably depend on member state to member state. So I don't know whether if something was was let's say, a decision of heads of states of different member states. I don't know whether in all the member states someone could challenge certain acts, accords that were adopted by their head of state. So this depends on the national constitutional regime. That I don't know. But it is certainly true that not everything is subject to the judicial review, but it was not seen as an unintentional gap. It was seen as a deliberate choice of the treaty makers. The second question was about legitimacy.
The fact it's political to exercise discretion.
It is political to exercise discretion. So the court doesn't want to see itself as a political actor, typically. So both in the extrajudicial writings of judges, you see often terms as we're not, the emperor of EU law, we're just the umpire who deals with small issues when there is a little problem of interpretation. But regarding this legitimacy, it is not only through judicial review, not only gives the court legitimacy, but I think even more it is important for the legitimacy of the other institutions. I have had many cases where both parties argue that it is admissible because the EU institutions in the case do not want to lose on, or do not want to win the case on admissibility. They want the action to be admissible and they want to win on the merits. They think that this gives them more legitimacy and more accountability, that they look better in the eyes of the citizens. They want to prove that they're right. They don't want for their acts not to be reviewed. And then this for Carvalho, so this is obviously a case that did not come to the court as an accident. So you see, by who the litigants are, that you have families from within the EU, from outside the EU, that you have indigenous communities. You see that someone thought this through, that there could be many angles of how to prove it. So definitely there was an agenda behind it. This comforting the court that someone else did it. This is always possible. I have heard before when in my academic work, I remember that these cases like tobacco advertising, when the court for the first time annulled a directive on the basis of a breach of the legal basis, this what is now Article 114, was wrongly used for a tobacco advertising directive. This was shortly after the meeting with the US Supreme Court that was at the time deciding similar cases about the American commerce, use of American Commerce Clause. So it is possible that courts get inspired through this, and certainly it is a message for the treaty makers. Also this CJEU, where the General Court went out with one interpretation and then the court struck down. This was clearly heard by the treaty makers, and this was clearly influenced the change in the Treaty of Lisbon. And now the final question was about how the court is becoming big. Yes, so we now have at the big court, which is actually a small court, there is one judge per member state, and then at my court, the General Court, there are 2 judges per member state. So we are introducing many measures on how to ensure coherence of the jurisprudence. So we have a vice president whose role is to follow all the rapport préalable. So before we write a judgment, we first write a preliminary report. This is done before the hearing, where judges discuss a certain case. And then if there is a similar legal issue appearing in more chambers at once, then we can have a coordination between chambers. Now, each chamber is independent, and each chamber can decide the case as it considers appropriate. But through this coordination, we usually try to find a common approach so that we would not come out with totally divergent cases, although we legally could. It would not be illegal for the General Court to have 2 chambers that decide cases completely differently, because we're not the Supreme Court in those kind of cases. Then we have working groups that seek to, in particular fields, to find convergence and so on. And once a year, we have like a big meeting of all the judges of both courts where we discuss some current topics. Whether this is enough, I don't know. But at the court, they have a weekly meeting called Réunion Générale. So there they discuss all the cases, and they discuss for each case to what kind of a formation it should go, whether it's a case that merits a formation of 5 or 3 or a grand chamber and so on. So already in deciding on the size of the formation, they are really deciding whether this case is something that should repeat existing jurisprudence or whether this case should move somewhere else. So it's not it cannot be a full system of ensuring coherence, but this is what we currently have. We're quite big, yes. It's huge when you come to the court. Bring students next year.
So, Judge Perišin and Professor Perišin, thank you so much for a wonderful lecture and a really stimulating, rich and engaging Q&A. Lots of questions thrown at you. Thank you everybody for your wonderful questions also. And despite the constraints of judicial protocol which you inevitably face, I think you've managed actually to offer us many, many insights and many fabulous answers, so we appreciate that very much. The one thing I will promise is that judicial mandates being fixed term at the CJEU, when your mandate finally, your final mandate comes to an end, we will certainly invite you back to find out what you really think.
You're all invited.
About the issues that we've addressed to you today. My experience is also as judges get closer to the end of their mandates, they become a little more relaxed about giving their opinion. So it's really been a wonderful end to our long and stimulating week. It's a warm Friday afternoon, and it's wonderful to be able to say with enthusiasm and genuinely that it's been a wonderful, wonderful way to end what has been, I hope, a really interesting week. So I'd like everybody to join with me to thank Judge Perišin very much for taking the time to come to visit with us here at the Academy today.